The Oregonians had that law in place till 1983, still in place. The only change since 1983 was in 2008 when we added to that general emergency law that the governor can waive a waiting period for unemployment compensation in those kinds of emergencies. The general disaster statute, as I'll call it, has no provision for public health emergencies. That phrase does not appear there at all. It does deal with disasters generally. Now, in the years 2003 to 2007, the Oregon legislature created a whole new statutory scheme relating to public health emergency. And in that statutory scheme, they defined a public health emergency, which includes the kind of coronavirus pandemic that we have in front of us that we're dealing with now as a society. And then they gave the governor special powers. They also put a time limit on those special powers. And one of the special powers that is not in the general emergency law, but is in the public health emergency law, is the power to close enterprises, businesses, buildings in order to deal with the epidemic. That special power is only in that law. That public health emergency law also contains a specific provision that the governor may call a public health emergency for 14 days, and within the 14 days, she can extend it by a second 14 days. So it has a 28-day expiration on it, and that is something that we are emphasizing in this litigation. Beyond that, in 2012, the voters of Oregon amended the Oregon Constitution. We added a new Article 10A. It was referred by the legislature. It was actually a revision. It was so comprehensive. And it passed the House 57-3. It passed the Senate 30-0. Talking about Article 10A, it was specifically presented to the voters, and it had to do with catastrophic disasters. And it's a complex, well-written constitutional change, which, by the way, no other state in the union in the last 20 years has done anything like this in their constitution. And among the catastrophic disasters, they included earthquakes, terrorism, war, all those kinds of situations, but also a public health emergency. It's already on the books defining a public health emergency. And the governor can declare a catastrophic disaster, which gives the governor extraordinary powers to deal with that for 30 days. But within those 30 days, the governor must go to the legislature if they're in session, or must convene the legislature if they're not in session, and let the legislature decide what else to do. They are empowered by a 3/5 vote of the House and a 3/5 vote of the Senate to extend the powers of the governor beyond the 30 days, but it's the legislature that has to do it. So we have three schemes here: public health emergency, 28-day expiration date, and we have the constitutional amendment for a catastrophic disaster, 30-day expiration date, and the general emergency law without an expiration date. Now, the governor is saying, via the Department of Justice, well, you read those together and the 28-day expiration date expires, goes away, actually, because the governor has also cited the general emergency law. We've looked at that and said, wait a minute, the general emergency law can incorporate a public health emergency, but the extraordinary closure powers of the governor that are only in the public health emergency law expire in 28 days, whether you stick it into the general emergency law or not. And that's the crux of the controversy here. So we presented this case in Baker County Circuit Court. The judge held a 3-hour hearing at all of our briefs, took 5 days to decide this, and issued a decision on Monday, carefully crafted opinion that was circulated to everybody, and the state immediately appealed to the Supreme Court. And in that appeal, they asked for an emergency stay. This proceeding is called a mandamus proceeding. What the Supreme Court has done is they issued the stay, but in the same order, they said, we want to hear from the parties as soon as practicable with their briefs, and no later than this Friday, May 22. That's important because under normal appellate procedure, we shouldn't be replying until the deadline of June 1. The Supreme Court has moved up the reply deadline, and I think they are sensitive to the time limitations involved in the issues that we're raising in this litigation. The last thing I want to say as a preliminary is we're not saying that Oregonians should be foolish about this coronavirus pandemic. We're not saying that they should be uncaring about their fellow Oregonians and pay attention to social distancing and whatever else needs to be done in order to protect our fellow members of society from this pandemic. But we are saying that the governor's superpowers, the powers to issue orders and prohibitions, which go beyond her normal statutory powers, have expired. She can still do things with the regular powers of the governor. She can still encourage and suggest and ask. And within the Oregon Health Authority and the Oregon's Occupational Health and Safety Act, she can take some regulatory steps to protect workers, to protect medical service providers. But what she cannot do is carte blanche, of course, across the state, issue orders that have to be followed by Oregonians on pain of committing a criminal Class C misdemeanor, punishable by up to 30 days in jail and a fine of $1,250. That is a very serious consequence that's embedded in her emergency orders using her executive director, using these directives by the governor. So that's the situation we're in. We will be filing our responsive briefs by Friday, and then we will see what the Supreme Court does to address this issue. These were not written remarks. This is just my attempt to give you an overview, and I'd be happy to take any questions. And it might be easiest if you just raise your hand, and or make sure I can see your video if you want me to answer your question. Kyle.
Kevin, thanks for taking the question and the time today. Aside from a Friday deadline to file those briefs, has the Supreme Court given you any guidelines on a timetable for potentially hearing oral arguments and or making any kind of decision? Beyond that, what are your expectations?
They have not given us a specific timeline, but I think the fact that they asked for expedited briefing shows that they're sensitive to the time frame, and I anticipate that upon the filing of the briefs, we will get further word from the Supreme Court about how they would like us to proceed, but I expect it will continue to be an expedited proceeding. Brenna.
Thanks so much for taking the time. I'm with Fox 12. I understand you have until Friday to file this response. Do you know how soon you'll file it, tomorrow, the next day, or will you wait till Friday to craft a response? And can you outline what will be in that?
Well, first of all, you know, attorneys, we're not going to file it at 1 minute before midnight Friday, and we're going to try real hard to get it in sooner than Friday. But we have a lot to chew on now in terms of the issues here, because this is the Supreme Court of Oregon. We want to make sure we cover all the bases. I will tell you that we're trying to put this into what I call the cosmic scheme of things, to point out that every state is different, that Oregon has its own statutory and constitutional scheme that we're asking to be applied here. And we may give some examples. For instance, in New York, Governor Mario Cuomo, he has a constant rolling under the New York statutes and constitution. Every 30 days, he can issue a continuation of his executive order, and he's been doing that. The governor of Washington and the governor of California have similar, not quite as extensive, open-ended capabilities. But there's other states where we see a 30-day opportunity, and then they can renew for 30 days, and they have to go to the legislature. In Oregon, I've already talked about the time limit that we see. The issues we're going to raise, we will talk about the principles, the constitutional principles. Imagine if the governor had said, I'm going to shut down all of the news agency offices because I don't want anyone involved. And I know a lot of you are working from home. A lot of my staff are too. Well, let's say the governor ordered you to have everybody away from the office, or ordered you to restrict your contacts in the community. We'd be saying free expression, freedom of the press. Well, the governor's done something similar in regard to religious rights. You can't assemble with more than 25 people, and even then you're going to have to keep the names and contact information for everybody coming to your worship service. These kinds of restrictions are not being applied to other institutions. Well, without getting into detail, we're going to be pointing out that there's a disparate application to Costco versus a Christian church or a synagogue. And why is there a disparate application? We'll also be we're trying to show how the governor's superpowers take her outside the normal range of what we would expect in our free society, to put this into context and to remind the executive, the Supreme Court of Oregon, that they are the one check on the governor's powers in the system of checks and balances. It's the court that needs to take a look at the statute. So those are the kinds of arguments we're going to make. I don't want to play too many cards on the table at this time, but that gives you an idea. Is it Jacoby?
It's Jason Jacoby, Kevin,
Jason
from
Jacoby.
the Baker City Herald. Thanks. Judge Shirtcliff, in his decision yesterday, cited the Colby v. Larson case, and specifically how the 433 chapter, because it's more specific than 401, should prevail. Are there other cases that you know of where Colby v. Larson has been cited as a precedent? And can you talk about how that applies in this case?
Well, Colby v. Larson is an Oregon Supreme Court decision. I don't have my citations in front of me, but that's a case that we cited to the judge. There are a number of Oregon Supreme Court decisions that specifically say that you need to try to read statutes in a harmonious fashion. You try to read them together. And there's some rules of interpretation that then apply. One is the specific controls the general. And in this case, the public health emergency statute is more specific about a time limitation as to the closure powers of the governor. Another concept is that a later enacted statute will be read to have superseded an earlier enacted statute if they are inconsistent. So the 1949 law is the early enacted law, the public health emergency law comes later, and if there's an inconsistency, the public health emergency law should apply. So those are the kinds of cases that we cited. It's a statutory interpretation code of law. Now, there's some folks that I can't see on my screen. I just see names. So if you're trying to ask a question, you'll have to say something.
Hey, Kevin, this is Tess Risky from Willamette Week.
Yes.
Hey, so this is more of just a clarification question. So if the court does rule in the plaintiff's favor, does this mean that all 20 executive orders Brown has issued since the pandemic began are nullified?
Yes, in the sense that, well, I would want to be careful about this. You'll have to go back and look at each of those executive orders. Some of the things within the executive orders may have been within the regular statutory powers of the governor. And if that's the case, they are not nullified. Let me give a very important example. The governor is the superintendent of public instruction under the statutes. We used to have an independently elected one. I didn't agree with the decision that we take those powers and give them to the governor. But we are now looking at the statutes in regard to the superintendent of public instruction. Maybe as the superintendent of public instruction, she has authority to close the K through 12 schools. I don't know that, but if there is statutory authority for that, that's regular statutory authority, and it would not be under the emergency laws. So there will be some instances of that. She certainly does have the authority to issue guidance to Oregonians, just as the president is issuing guidance to the 50 states. But the 50 states are individual entities, sovereign entities under the federal system. So they can listen, but they can also implement as they wish. So she still has the capability to do that. And then within her agencies, she has some regulatory authority that may have been implied into her executive orders here. And so I'd say there is a savings opportunity as to her usual statutory and regulatory powers, but any superpower that she has claimed has expired, and to that extent, they will not apply.
Okay, thank you.
Anybody else?
Kevin, this is Dick Hughes. From what I've read, the churches involved are saying they would plan to practice social distancing, such as leaving every other pew vacant, being 6 feet apart if they're not from the same family, et cetera, et cetera. Is that your understanding? Because there seems to be different points of view that people want to rush out and sort of just all congregate for the sake of congregating, or we want to do this responsibly, but we want to have the authority to do it ourselves, the responsibility to do it ourselves.
Well, I think there's a certain symbolism to the large number of church congregations and church members who have come into this case. These are generally law-abiding citizens who care about their brethren in the community. And they're not saying we want to run roughshod over common sense things that we can do voluntarily to protect our fellow citizens. I happen to be Catholic. I want to be able to go to Mass. I want to be able to be there with my fellow Catholics. At the same time, I would respect the idea that we ought to have some social distancing to the extent that the coronavirus pandemic is affecting our community. But if I go out to a rural county where there are 0 cases, I probably feel a little more comfortable, and I wouldn't feel like, gee, we have to be, measuring 6 feet apart. It depends on where you are, and you should be responsible in that context. So we're saying we encourage people to voluntarily do smart things, but the governor cannot order us under pain of criminal prosecution to close our businesses when the businesses can be following reasonable practices that will take care of their customers and themselves, or to close our churches effectively. I'm a member of a church which has got many hundreds of members, and they figured out if we're allowed to only have 25 people attend Mass, and we have like 8 Masses on a weekend, it would take 5 months before all the members of our church could go to Mass once on a Sunday. And by the way, the governor's directives are presently saying you need to take down the name and address and contact information for everybody who has attended, and then you have to provide that to the state if they determine that they need to trace somebody. That's a pretty scary provision, and that's one of the things the governor would not have the authority to do absent her superpowers. I get excited about this. I'll calm myself down a bit. But I think it's an important discussion about Oregonians, how we can be responsible citizens without being treated like children and wards of the government. I may schedule another one of these sessions at some point to provide an update. I appreciate you all checking in. Was there any other question that I missed? Well, seeing none, I wish you all a good day, and I do want you to take care and stay healthy. Thank you.